This is Michael Popok, Legal AF. Let's check in on Judge Cannon, Southern District of Florida, federal judge, and question whether she has decided to become a member of the Trump defense team based on the rulings that she's made that have made it an almost certainty that the trial of Donald Trump related to Mar-a-Lago Espionage Act and the obstruction of justice will not happen before the election in November, certainly won't happen before the Republican convention in July to select their nominee. And it's based on a series of decisions, this slow creep of decisions, all in Donald Trump's favor, which will completely undermine any ability to start that trial in March as she originally, in May as she originally scheduled. Let's go through the most recent decisions that she's made that aren't head scratchers, not if you agree with the theory that she is putting her thumb on the scale in favor of Donald Trump. In the NBA, when the referee seems to be making all the calls for the other side is heard to complain that they're playing against 6 men instead of 5. Same thing may be going on here. Let's start with what she's done. Firstly, the judge has denied the Department of Justice's request to speed up, at least on a normal course, the process by which the classified documents at the heart of the case, this is after all a classified documents case, the classified documents procedure, the Classified Information Procedures Act hearing, so that the parties can once and for all determine which documents will be used at the trial of the 1 terabyte of information provided to Donald Trump, which are the ones that are going to be presented to the jury and the judge that they have to fight over now to sort out. Because once those are identified, then the government knows what to ask for next, which is any kind of special presentation of that evidence to the jury out of the prying eyes of the public if they remain national security secrets. But you don't get to that until the documents are identified. Sounds pretty straightforward. Which documents are the parties going to use? Which documents is Trump going to use? He's had, 9 months to review the documents. Which are his key documents? And they asked the judge to schedule a hearing like now in 2023, because that trial in May in 2024 is really fast upon us. And the judge says, nope, we're not going to do that hearing until March of 2024, just 2 months before the trial. So they're going to fight and litigate and maybe have a series of appeals between March and May of 2024 over the key issue in the case. That makes absolutely no sense. And I can't imagine a federal judge on planet Earth, not named Aileen Cannon, that would schedule such an important hearing on a fundamental issue related to the documents and the exhibits in the case that go to the very crimes in the case for 60 days before the trial. It's almost unheard of. It is unheard of. That's the first thing she did. And the second thing she's done is that in terms of trying to slow things down in terms of a process, has to do with the facility that she required be built near her own courthouse up in Fort Pierce to allow for the confidential review of the confidential information. That's called a SEPA facility. Not every courthouse has a SEPA facility because not every courthouse regularly deals with national security information. And I assure you, the sleepy backwater town of Fort Pierce, Florida, where I have actually practiced and appeared in that courthouse when I practiced in Florida, is not a courthouse that gets regularly national security information and espionage cases. But Miami, which is also in the Southern District of Florida, a federal district that runs from Fort Pierce down through Key West in Florida, with courthouses in between, Fort Pierce, West Palm Beach, Fort Lauderdale, Miami, Key West. Miami, where the chief judge of the district sits, Judge Altanaga, has its own facility. This trial really belongs, as I've said at the beginning of Legal AF 8-9 months ago, it should have been assigned to a judge in Miami, or Judge Cannon should have been required to conduct the trial of this case and major pretrial proceedings in Miami, which has a SEPA facility already built in Miami. Miami gets a lot of drug cases, gets a lot of international cases. So it made sense that there is a hardened, built bricks and mortar SEPA facility in Miami. There wasn't one in Fort Pierce. So if you want to slow things down, require that a facility get built in Fort Pierce. This will be a disposable facility, folks. There's never going to be another case in Fort Pierce that's assigned that has obstruction and espionage attached to it. So the taxpayer dollars ordered by Aileen Cannon into the millions to build a facility for one-time use by Donald Trump's lawyers. Now, here's a little bit of geography that the judge also knows but doesn't recognize. Donald Trump's lawyers aren't in Fort Pierce either. Donald Trump, when he's in Florida, is in Palm Beach County down in West Palm Beach. So maybe you build the SEPA facility in West Palm Beach. No. She built it in Fort Pierce, which is an hour north of West Palm Beach, for her lawyers, one of which is in Tallahassee, which is at the top of the state. It's the state capital. That's Kais and Todd Blanche, who's in New York, and John Lauro, who's in Tampa on the west coast of Florida. So nobody's in Fort Pierce. Certainly not Donald Trump. So why are we spending taxpayer dollars to build a hardened facility of SEPA review in Fort Pierce? Why? Because it delays. It builds in a series of delay for the ultimate trial. Because as the judge announced in November this month, that facility is not even going to be available to use by Donald Trump to review documents until early 2024. Another dragging, lagging delay built into the schedule. So don't hold your SEPA hearing that's required to identify the documents to have the fight over the documents until March. Don't have your SEPA facility, which you don't even need if you just did the case in Miami. Don't have that built until early 2024. And what do you got? You got no way to try a case in May of 2024, and certainly not one that will time out in advance of the July Republican convention, so the voters won't know if he's a convicted criminal or not, or, at least in Mar-a-Lago, or spills over past the November election. And so you see why some people are speculating that she's become a member, Aileen Cannon, of the Trump defense team, right? And so the other reason the identification of the documents early is so important is this issue of what's called gray mail and the silent witness rule. So let me do a little breakout session here of Legal AF Law School on the silent witness rule and gray mail as it relates to classified information under the SEPA statute, right? If a document is identified by Donald Trump's team as something they want to use in their defense, an Iranian war plan, something about nuclear secrets of one of our allies, something about Israel at the given moment, that's still active live intelligence. In other words, it's not so stale. Or even if it is stale, it's not something we'd want the world and our adversaries or enemies or even our allies to know about. There's a procedure. He can use it, but to avoid the issue of what's called gray mail, where he threatens to use a document, right, that the government doesn't want him to use, and they have to therefore drop that part of the prosecution because they don't want the document to be revealed. In other words, the cost-benefit analysis is such that they'd rather not have that document falling into the wrong hands is more important than even prosecuting Donald Trump, and so they drop that part of the prosecution. That's what the defense hopes. The solution for that is something called the silent witness rule. It's been developed by common law and by judges. It's not technically a provision of the Classified Information Procedures Act, but it's something courts have used as a prophylactic measure to allow the prosecution to use the document, to allow the defense to use the document and not drop it, but avoid the government being blackmailed or gray-mailed by the defendant who says, oh, if you continue to prosecute me, I'm going to use this secret document you don't want me to use. And so they use the silent witness rule, which means the document gets used. The jury, who will likely be hopefully anonymous here, the jury gets to see it, the judge gets to see it, the defense gets to see it, the clerk gets to see it, but it's sealed. It's not made public. It's not on the public docket. The press isn't allowed to report on it. And that's the silent witness rule. Sometimes that silent witness rule even takes another form where the witness is also somebody who's an undercover a covert operative, a CIA agent, somebody whose identity, if revealed, would blow a cover, blow an operation, put himself or the national defense or national security in harm's way. And so they're allowed to testify unusually, with a disguise, having their voice disguised behind a divider so their identity is not revealed. Now, that is generally against the Sixth Amendment right and the right of the constitutional right of a defendant to address their accuser, right? To be able to see who it is, to be able to cross-examine them and know all about that. But there are procedures in place where they both get the ability to cross-examine vigorously that witness, and the witness's identity is protected. And that's another aspect of the silent witness rule. But you can only do all of that, the silent witness rule and the come up with the procedures for not having the document be public, when the documents are properly identified. And then there's a fight over them in front of this judge. And if we don't like the outcome of that fight, it goes up to the appellate court, the 11th Circuit Court of Appeals that sits in Atlanta. But there's not enough time, do you see, between March and May. The March date, the judge doesn't want to be bothered until March. She's apparently too busy. She doesn't want to be bothered with the SEPA issue, the gray mail issue, the silent witness issue. How do you present this case that's fundamentally about classified documents? And she doesn't want to hear about it until 2 months before trial. Which begs the question, what is she doing that is more important than the proper trial of the former president of the United States who was indicted for committing Espionage Act and obstruction of justice violations? What is on her docket that is more important? And I'm going to answer my own question on this hot take. Nothing. I don't care about a drug case up in Fort Pierce, an immigration problem in Fort Pierce, a civil trial in Fort Pierce. I don't care about any of that. America cares about whether Donald Trump is guilty, right? Prosecution doesn't mean conviction. It does apparently in Aileen Cannon's mind. Prosecution means a public trial to determine a person's guilt or innocence, done in an expeditious fashion, which is to the benefit of the defendant and to society at large. He shouldn't have this hanging over his head if somehow he's not guilty. Now, look, we all know, based on the evidence that just we understand exists, that Donald Trump's chances of winning a case in front of a jury is not that great. And it looks like the judge knows that too. Just to put a fine point and give you a metric for the judge that indicates that she's got nothing better going on. Out of all the trials that's been assigned to her, there's 224 of them on the criminal side since 2020, since COVID. 224 trials, including Donald Trump is one of those. Do you know how many of those cases have been properly prepared for and gone to trial in her courtroom? 4. 4 out of 224. And just to give you some context, as a trial lawyer, that's a ridiculous statistic. I can't think of another federal judge, right, who has in federal court that has only tried 2% of her cases assigned to her in 2 years. That is a terrible statistic. And if I were the chief judge in Miami, who gets the statistics on a monthly basis, I'd be having a conversation with Aileen Cannon about how she's handling this case, if that conversation hasn't already. Because she's left very little time for the full briefing, oral argument. She takes weeks, sometimes months, to do what other judges do in days in federal court. And we see it because she has a comparator in Judge Chutkan handling the DC election interference case. Judge Chutkan briefs and rules within a week, rules within a day, right? Same thing given over to Judge Cannon. Weeks go by, months go by before a ruling comes out, and the ruling has built-in delay in it, right? The ruling is delayed, and the ruling has more delay built into it, and that's all we've been seeing. I mean, I've kept my powder dry about Aileen Cannon for a long time, but there's no other way to explain what she's doing and who she's benefiting than what I'm doing on this hot take. We'll continue to follow Aileen Cannon with all of her rulings. I'm not sure there'll be another one before March at the rate she's going, or what the Department of Justice's game plan is to get this away from her and up to the 11th Circuit. And just as a reminder for people that are new to Legal AF, that podcast at the intersection of law, politics, and justice that we do every week, twice a week on the MeidasTouch Network on this YouTube channel. Remember, this is the same judge, and we got a preview of this already, who decided the way no federal judge in history has ever done, that she was going to intervene in the middle of an investigation of a criminal defendant before indictment to try to interfere with the investigation and stop it in its tracks and make the FBI, the Department of Justice, justify their investigation while it was ongoing before they had even indicted Donald Trump. She did that twice. She said it was extraordinary circumstances because this is a former judge, a former president. No, it's not. This is the criminal justice system, and the judge has no role in the prosecution or investigation leading to an indictment, unless and until there's an indictment. That's when they step into the case. The magistrate judge has a role that sits under that person, issuing subpoenas, managing the subpoena process, the search warrant process that happened in Mar-a-Lago, for instance. But the judge, there's no role under the criminal rules, none, or constitutional law. And she was told that twice, where she was reversed twice by the 11th Circuit Court of Appeals, including with Judge William Pryor, the chief judge, before the indictment. So you'd think, well, maybe she's a little bit chastened now. All right, okay. Maybe a little singed. She'll do better when she finally gets the case on indictment. Nope. Case gets assigned to her on indictment, and now you see the results. We'll continue to follow everything about the Mar-a-Lago case and shine a bright spotlight on it and on Aileen Cannon's judging. Only one place, the MeidasTouch Network, on Legal AF. The title's what you think. On the corner of justice, politics, and law. Every Wednesday and Saturdays, audio podcast platforms, wherever you can get them. And then I do hot takes like this one about every day. Sometimes it's 3 and 4 times a day, depending upon what issues are going on. And the leaders of Legal AF, with collective 75 years of legal and trial experience, bring it to you in one place exclusively, MeidasTouch Network. Free subscribe, help them get the 2 million. They're so close to 2 million free subscribers, because the bigger they get, it helps have your voice heard. Right? No outside investors, grassroots media company. Here we are, mom and pop. But we're bringing it to you on a regular basis with content just like this one. Give me a thumbs up on this particular content. Leave me a comment. Until my next hot take. Until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.